Good evening, everyone. Thank you once again for sticking with us, and thank you, Minister Lightbourne, for that informative presentation of the consultation thus far. I would like to remind you all that at this time we are transitioning into our question and answer period, and I'd like to take this time to introduce Karen Marshall, who is the Executive Officer and Commissioner for Consumer Affairs. Karen is our subject matter expert on this evening, and Minister Lightbourne will also be here to answer any questions. I would like to encourage you all to utilize the chat function on YouTube and Facebook so that we can see your questions. And once again, for those of you who are watching and listening from home on CITV, please remember to send your questions to mhahq@gov.bm, or you can also visit forums@gov.bm as well. So while we're waiting for questions from the audience, I would like to start us off with a couple of questions that I thought would be interesting to start us off. So either Karen or Minister, what are the top 3 problems this reform must solve, and what kind of key performance indicators will you use in the first year and then going on to year 3?
So I'll begin with just the top forms that I believe the government seeks to advance. In the first instance, it's including fairness, ensuring that there is enhanced rights. We've heard from the public that these are things that concern them and that they wanted to see both landlords' rights strengthened as well as rights for tenants also strengthened to provide a level of clarity and also ensure that they could easily get relief should they need it.
Thank you. The consultation paper estimates that cutting the average resolution times from 6 months to as little as 44 days in arrears cases. What kind of resourcing or workflows and performance targets will underpin that figure?
Okay, presently the eviction process is set. And it's not really going to change with this legislation, but the big change will be the tribunal, because you don't have to wait to go through the courts to get your order of possession. You still have to give your month's notice and all those sort of things, but the tribunal will be able to make a decision pretty quickly, and then you'll be able to get the tenant out without inducing any more debt to yourself and to the tenant. And so that, in that respect, will make it a faster resolution of time.
And I'm sure many people will be appreciative of the shorter time frames. In the preamble for the bill, it refers to residential and agricultural tenancies, yet the text does not clearly limit the application of those. Can you explain and what the confining scope would be, and to preserve the 1974 Act's parts?
Okay. What you're talking about is commercial acts, and basically we will be addressing that in the second draft. And because we do understand that there is a large turnover of property through to probate, through just people buying houses and that sort of thing, and the conveyancing process and being able to rent it out for commercial use is one of the things that has always been a problem. But the Landlord and Tenant Act did cover that, but we're going to make sure that it's in the new Act, and we'll have regulations to make it easier for lawyers and for residential owners, well, not residential, but commercial owners.
And Karen, I know you're intimately involved as head of consumer affairs, not to jump in, but you have been on the front lines of many of the challenges between the landlords and the tenants to date. So maybe you could also share kind of what you had seen and also how they've been resolved in some of the provisions in the bill as well.
Yeah, a lot of things we were finding is that people weren't using leases, and that was causing major problems. So we created leases, and you'll notice that there are leases in the new Act. One of the things that we find is that there was a lot of both sides, from the landlord and the tenant, violence, not doing what the terms and conditions of their lease were had stipulated if they had one. The mere fact of unfair contract terms where they were nickel and diming tenants. We also had a lot of illegal trespassing by landlords into the property, which is really breaking and entering if it's during the day. And so those sort of things, because you're entitled to peaceful enjoyment of your rental unit. We also found where tenants were subletting, even though they were on the lease, and they were making money and profiting off the landlord's asset. And so those are some of the things that we're addressing in the new legislation.
Great. We have a question from the audience. This is from Platinum Realty Global, and they're asking, good evening, will there be a nominal fee structure or no fee for the tribunal cases?
Okay, usually there is a fee, and that will all be part of the regulations that will be hammered out with the minister and the drafts people as to how they want that to go. But there is always a fee.
Will the bill include explicit transitional saving provisions so existing leases and rights under the 1974 and 1978 Acts continue smoothly?
Can you repeat that?
Will the final bill include explicit transitional saving provisions so existing leases and rights under the 1974 and 78 Acts continue smoothly? I guess.
Yes.
Whether it's grandfathered in.
Well, if they, it is dealt with in Section 5, and it's also dealt with in Section 4. What it states is that leases that are already in existence, they'll have a termination date. But once the repealing of the other two acts, they really become null and void. So there will be a time frame which the minister will decide as to when they have to actually implement the new leases from the act and use those terms and conditions so that it complies with the new act that's going to be in place.
Thank you for that.
And similarly, I would say that the spirit of the reform mirrors what took place when we reformed the employment laws in Bermuda. We consolidated them. We now have a singular piece of legislation that governs all employment contracts, includes a standardized lease terms of engagement and employment, and the same will be true for what we're intending to be this consolidated and also modern bill.
Modernization is the key. So regarding some tenancy agreements, Clause 13 requires 60 days notice for any rental increases. With the tribunal able to review what's fair and reasonable, will the regulations define objective criteria, either inflation index or what the market says, the condition of the apartment, or is so that it can limit subjectivity of what people think it should be?
I think one of the things you have to keep in mind, if they're under a lease, that's a contract. And you'll notice that it also talks about contractual legislation that they are being governed by. So if your lease doesn't end until another 2 months, they can't put the rent up anyway until that contract is complete, especially if it's got the stamp duty, because that makes it even more legally binding. And the 60 days, I think, is fair in the fact that we kind of do that under rent control. We give a time frame for because we always inform the tenant if there's going to be an increase and that sort of thing, and they're part of the process. But under the Landlord and Tenant Act, as soon as the lease is up, they can put the rent up to whatever they wanted to, and there's some of that also in this. So it's not restrictive, but 60 days is something new that's been added to the Act.
Okay, thank you. We have a couple of questions from the online audience. This question comes from RM90, and there are concerns about invasive and discriminatory questions that landlords and realtors may ask during the tenant screening process. Are there going to be any new measures that are introduced in order to prevent that?
There are no measures at this point now, anyway.
But under the Human Rights Act,
Yeah, that would- yeah,
by
if
way
you're-
of realtors, they're governed by discriminatory practices, and so the Human Rights Act actually, though not explicitly included in this draft bill and the current legislation, they would be similarly and consistently governed by those sorts of discriminatory practices, for sure.
Great. This next question is from back in the day, and they are asking a question that we actually had a short discussion about prior to going live, which is regarding a disabled tenant in a rent control property being evicted to make way for a caregiver for the landlord. Does that fall under, I guess they're asking if that falls under eviction for private use of the landlord, say a relative is needing possession, need possession of the apartment.
In terms of eviction, much like the current law would be prescribed, you cannot use discrimination to support an eviction of a person. The landlord would be governed and also expected that they would be reasonable as well as not deploy discriminatory practices. So that would be true. I think homelessness is a part of what the Ministry of Social Development and Seniors is similarly seeking to address by way of support services and kind of wraparound services as well. Naturally, once they are in a stabilized place of abode or home or tenancy, then they would be able to be governed by the Landlord and Tenant Act. So,
okay, great. Another question from our audience. This is again from Platinum. And regarding Section 22 and 41, from a landlord's perspective, will a time period be stipulated for where a tenant becomes responsible for further or related damage due to a delay in reporting? Meaning?
well, at present, the 30 days post agreement by way of the tenancy agreement as well as the deposit return process, they would have to declare that it is eligible for a deposit to be returned. So an increased time frame is not something that's currently being contemplated, with the view that the landlord would make best effort upon termination or the end of a lease for the necessary revisions as well as maintenance checks are done to ensure that the deposit can be returned. So I'm not sure if there's a proposed extension, but it's usually 30 days after the termination of a lease.
Yeah, and that's also common law. The question seems a little odd to me, due to the fact that if the tenant and the deposit has been used to put the tenancy back in tenable condition because the tenant didn't do such a things, then they would have the opportunity to deduct those things, but they have to provide receipts as to what they did. And if it came to a dispute about it being more, the tribunal would be the best place to step in and deal with that. And that happens quite often, but also a lot of times landlords don't have the money anymore, so it's that catch-22, which in the ministers, in her bill, landlords have got to put it in escrow so that it doesn't go amongst the missing, which happens very often.
Okay. Under, with regards to rent control, how will Part 7 replicate or intentionally change security of tenure protections and termination grounds under the current rent control? For example, own use renovations, which commenters have said is missing or is diluted from the new bill?
It's actually missing from the new bill. So there's two things that are missing. One is if a landlord or an adult child wishes to move into the apartment. And the other one that's missing is the major renovations. Those were two of the reasons you could actually evict somebody. But they're not in the actual act.
Which is intended to be in the regulations
And that could
yes.
be reestablished because because that whole act was about security of tenure. And so there was only 4 reasons that you could evict somebody. 2 have been kept. The other 2 are not does not appear in the act.
So I have a comment that someone sees as a challenge in the new act. This is from Bermuda Steve. It says the two parts stood out as being material challenges. 1, security deposits being up to 3 months of rent, and 2, proposed late fee looked punitive from being worded as a daily late fee.
And this is something that we've actually received by way of the current consultation with a view to standardize it in terms of reducing it to what is currently 1 month's rent deposit. We don't want the up to 3 months to then be a mechanism for it to also create greater hardship or disparity for persons who currently are already seeking challenges finding affordable accommodation. And so that is a provision that will be reflected and adjusted to be 1 month in the future draft that we will share for review.
Awesome. One more question from RM90. What is, landlords often act without fear of consequences because there are little to no enforcement mechanisms. What specific changes ensure landlords face real repercussions for illegal or unsafe rentals?
So several panels. This is one that we've discussed with both the drafters, et cetera, to be able to be reflected. Of course, enforcement is a huge portion of the success of what is enacted in law. And I think, even you, Karen, I'm happy for you to weigh in on some of the challenges that you've seen kind of happen in practice that become difficult for even the consumer affairs section in managing current rent control properties.
Yeah. Under the acts as they stand right now, the courts are the only one that can enforce these issues. That's why there's a whole section on maintenance, and because those are some of the biggest issues. The one thing that they can do, and it is go to environmental health, who will come out, because we, with Health Department, Consumer Affairs, wrote the housing regulations. And that states how the house should look. No dampness. It should have a window here. It should have this. And they have the power under that act to enforce it, to make the landlord do these things. The problem with the acts 50 years ago and inexpensive, they didn't give any powers to the rent commissioner besides adjudicating rent. So that's one of the biggest problems. And the landlord and tenant, everything has to go through the courts. So that was the way it was done. Everything went through the courts. And the landlord and tenant, the Rent Increases Domestic Control Act was actually written by a magistrate. So, and he was the first rent commissioner. So that's probably why that went that way.
Let's ask a few questions about the tribunal design and what that looks like, because this is something new for everyone. Anyone who's a landlord or has had to do some kind of eviction knows that you usually go to magistrate's court and you go through that process. So this tribunal will be a different look and feel for persons. So will the tribunal be defined in the interpretation section, and will clause 35 actually specify the board size, what constitutes a quorum? Some of the legal reviewers, I think, have asked those questions.
In short, yes, and also a reminder by way of the intention is to not create greater nuisance, but to actually streamline the challenges that persons are saying that they are dealing with. Persons shared, and the ministry would have received kind of a consolidated list of items and concerns that the public had raised, and also shared, including the legal fraternities, who shared that these are some of the challenges that are faced by tenants and landlords, and a landlord being able to know that they can quickly remedy a tenant who is in breach of their contract is something that we are seeking to advance on behalf of them, and also similarly for a tenant who seeks to quickly get their challenges resolved. And so the tribunal is sent to be that adjudicating body to be able to quickly remedy these concerns, and in the event that they are unable to, there is a mechanism for them to appeal to the magistrate court.
Great. Will there be a clear appeal filing deadline, which will allow for the courts to make such other orders that may be appropriate?
Yeah, there will always be that mechanism, because you can always appeal to the Supreme Court, and the way it's written is for judgment of a legal terminology. One of the things about the tribunal and the drafts people will do, they'll cover all those bases that you normally see and have it laid out as to how the tribunal will work, the forms that people will need to fill out, and all that sort of issues, so that the process can move quite quickly, and they will also give any sort of boundaries as to what's got to go to court and what's not got to go to court.
Now here's another question, because everyone always wants to know about this, especially when it comes to government and the things that we do. How will the tribunal's powers under Clause 40 to 43 be resourced to ensure consistent and timely decisions? This is when they're meeting on things such as repair orders or possession, compensation, things like that. How will we ensure that the tribunal has the right resources to do that?
And this is part of the feedback that we received, and also acknowledge that in refining these very, very outdated laws, that we wish to quickly get to providing modern legislation, but we also don't want the speed to be at the expense of full comprehensive reform that is reflective and also efficient and effective in the way that it's executed. And so based on the feedback that we've received over the past month, that's something that will be further refined. Further consultation will also take place to ensure that the necessary mechanisms have been thoughtful as well as refined and included.
Now, I'm sure that the persons who will make up the tribunal will all be subject matter experts and stakeholders in the field, and will be a variety of people. However, even those people sometimes need a bit of training. So what kind of training and guidance can be provided to tribunal members? And will there be an annual performance report, data dashboard as part of their oversight? All kinds of reports that people like to have and see, either yearly or quarterly, whatever that looks like. Will something like that take place?
I think we'll consistently refine. I think both providing transparency in terms of the success of what this act does deploy will have to underpin whatever takes place. We will anticipate that there may be little tweaks that we will have to further go to Parliament to then remedy. It will be difficult for us to foresee at the outset everything that is intended or what could be fixed, but this is why the consultation and the process that we're currently going through, we now recognize that things that at the time that these two acts were advanced were not reflective and sought to be reformed, and they probably thought at that time that it was near perfect as well. And so I think that is just the nature of laws, and that they represent current state and the day, and so they will have to be refined through policy, through future engagement with the public, to ensure that it is accurately protecting those that it seeks to protect, that is the landlords and the tenants.
Great. Several submissions asked for transparency in ARV methodology used across rent control. Will the government publish the valuation factors or consider broader rent stabilization tools?
So one of the things that has come up in the consultation is around a rental registry. That's something that has been discussed, and by way of ensuring that there is transparency across property sizes, etc. The ARV is a tax framework that the authors of the Landlord and Tenant or the Domestic Premises Act sought to use as its standard. And so I think there are still questions that the government and also the ministry will have to ask by way of what is the standard that will seek to underpin the rent control, and how do we strengthen it to ensure that it's effective and reflective of current state.
Another question from our audience. Okay. From a tenant's perspective, will there be any specific protections included for tenants with child occupants, and also for those who are senior and or disabled?
She's asking for protection for the child instead of being put out.
The question wasn't specific.
Right now, basically, those factors are taken into consideration by the magistrates, but when you, and I know I say this all the time to nauseam, this is somebody's asset, and you've agreed to pay this rent, and you've agreed to do the terms and conditions under the lease. And to think that you can just live there for free or do whatever you want is not on. And basically magistrates will take into consideration that you have a child and that you need a lot more time to find somewhere else to go, or to find specific help. And some magistrates are pretty good about, okay, you need to go see home, or you need to go see financial assistance and those sort of things, and they'll give them the key things that they need to do. I just get a little concerned that with some people, they seem to think that the apartment is theirs and that it doesn't matter whether they pay or not. I've been in some apartments where people have just wrecked them, and before they moved in there, they had spent thousands and thousands of dollars on it. And magistrates don't take kindly to that. And it is somebody's asset that you're dealing with. So I have sympathy, and I do understand that you can get yourself into hardship. The government has provided quite a few different agencies that you can look into and receive the help that you need.
Definitely about balancing fairness for all parties. There would never be an effort to create this condition where a mother with a child is put in an adverse situation, but likewise providing a framework for persons to do the right thing and also have access to support should they need it, either through a tenancy agreement that has gone awry, or naturally there are also government services and entities, to Karen's point, that have also been constructed to provide that support and relief. All right.
So let's ask a question around municipal and commercial properties. If commercial leases are out of scope in the final bill, will government confirm that existing expectations under the 1974 Act continue to apply to those?
So our intention is that before this bill goes to Parliament, it will reflect commercial leases and the leases that are not currently included. And we've been confirmed through these provisions by the consultation that's been conducted to date. So we're pleased about that. And we will ensure that that is included.
Great. So at this time, we don't have any more questions from the online audience. I'd like to take this time to say thank you to the both of you for giving your time this evening. I want to say thank you to the audience who stuck with us through some of our earlier technical difficulties. But again, I want to reiterate that this consultation process finishes on October the 31st, and you have until then to actually put in your comments, ask any questions, view your concerns, and during this time, if you'd like to, I want to give you the information again. I think this is the fourth time this evening that I'm giving it, but as long as you give it multiple times, then people can't say that you didn't get it. So if you are at home and watching on CITV or after the broadcast has concluded and you say, you know what, I wish I would have asked this question, here's where you send it. You're going to send it to mhahq@gov.bm. Or you can go to forum.gov.bm and put all of your questions and your comments there as well. Once again, I want to remind you that the consultative process closes on October 31st. So you have a few more days, 2 more days, to get all of your questions and comments in and be heard with regards to this legislation. It was, 1978 that this legislation, it's not older than me, but close. So this is a great time to be able to put your stamp and really become involved in what's happening so that you can say that you've read it. Most of us out here are landlords or tenants, so this does affect all of us. So, Minister, do you have any closing words that you'd like to give?
Thank you very much for your participation and being willing to moderate. Also, we should thank Ms. Marshall, who is the head at Consumer Affairs and has been on the front lines for some time relating to the challenges that the public has had. And so we thank the public for being engaged. We intend to ensure that all of your concerns are reflective in the future draft bills that we will seek to hear your feedback and also ensure that we've gotten it right. This marks the start of a process to refine it and ensure that both the landlords and the tenants' rights are evolved to address modern challenges and also reflective of what the community has said. And so we thank you for your feedback. We thank you for the emails that you send. We do receive them, we do read them, and we will be using them as instruction for the future drafts. So thank you for your time this evening, and we look forward to reform and modernization of the Landlord and Tenant Acts. Thank you.
Thank you so much, Minister. That's a great way to close out this evening. To the audience at home, I'd like to say thank you again for tuning in this evening. And also, please, from all of us, stay safe during Hurricane Melissa. Have a good night.